additional discovery, and you received that, Mr. Wagner.
We have, Your Honor.
All right, your discovery will be due by final pretrial. I don't see that it's been filed yet. You anticipate any pretrial motions?
I do not. If I may, Your Honor, I was out seeing Mr. Ruby yesterday, and the state has, we reached a resolution, so I'll set up a plea with Marshall, Your Honor.
Oh, okay. All right. Then we'll continue here, I assume, maybe next week, Mr. Woodley, thank you.
Yes, sir.
All right, who's your other one, Mr. Wagner?
Mr. Collins, Your Honor.
All right, Donald Collins, please. Mr. Kirk, Mr. Osborne's here in the courtroom, so when we're done with you, you'll need to come over here.
Okay.
Your initial king. All right, you're Donald Collins.
Yes, sir.
All right, this is case number 22, CR 92, State of Ohio versus Donald Ray Collins. Mr. Collins is appearing by Zoom from the jail. This is pre-trial. His attorney is Jacob Wagner, appearing by Zoom. Also from the prosecutor's office, Mr. King, assistant, appearing by Zoom. Defendant was indicted with 4 co-defendants, and looks like he's indicted in counts 1 and 2, 10 and 11. This is a first pre-trial, I believe, and final pre-trial is set for May 18. Trial date is June 13. See that there was a request for discovery filed on the 13th. As the state complied with that discovery request.
We've got discovery, Your Honor.
All right. All right. Defense discovery will be due by the final pre-trial. And you anticipate any pre-trial motions?
No, sir.
And has there been a written plea offer provided?
If I may, not yet. Mr. Collins and I have spoken. There's still, we're still in the process of that, Your Honor. I will not see my client already about the discovery.
Okay. All right. Any other matters need to be discussed at this time?
No, sir. Thank you.
All right. Thank you.
Thank you, Your Honor.
All right. Kyle Smallwood. Do you have anyone else in jail besides him, Mr. Kirk?
I believe Dustin Green may still be in
Oh,
jail.
yeah, there is. Yeah. No, I'm not sure if he's still. Is Dustin Green still in custody, officer?
No, he is not.
Okay, I thought he bonded out. Yeah.
I guess they'll probably show up in person then.
Well, that would be your hope.
Exactly.
Yeah, he did show up at the probation department, so we'll see. All right. This is case number 22, CR 78, State of Ohio versus Kyle Smallwood. You're Kyle Smallwood there at the jail? Officer, is that Mr. Smallwood sitting there with his head down? Okay. All right. Before the record, the court was informed that Mr. Smallwood didn't want to come to court, and I explained to the officers that that wasn't an invitation, it's a mandatory thing, so they had brought him to the room. He's got his head down. Mr. Kirk is his attorney. This is being conducted by Zoom. Mr. Kirk's appearing from his office, and then also appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged with trespass and habitation with a person present on the present fourth degree felony. This is the first pretrial. We have a final pretrial on the 4th of May and a trial date on the 12th. Now, I have received a motion to file, looks like this morning, for a psychiatric evaluation to determine the defendant's competency and sanity at the time of the alleged offense. Mr. Kirk, have you discussed this matter with Mr. Smallwood?
And not recently. I had him at the preliminary phase, attempting to discuss it with him then, but I've not had much luck being able to communicate with him.
Has he been refusing to see you?
I have not been back out to see him recently, so I can't say that. I know this hearing and the last hearing he's not wanted to appear.
All right. Well, Mr. Smallwood, I'm going to order that you be examined by a psychologist. That I don't know if they're going to come to the jail or if they'll do it by Zoom, but you need to cooperate with them. It'd be in your best interest to do so. You're not going to do anybody any good, including yourself, particularly yourself, by being uncooperative. I don't think that's due to your mental condition. I think you're just being difficult for no reason. And if you think that's a good legal strategy, you're sadly mistaken. So they'll be in touch with you probably within the next 2 weeks. So I would urge you to cooperate with them, because if you don't, they're going to file a report that says they can't give us an opinion. Then you'll have to go forward without that benefit of that evaluation.
I already had an evaluation.
Well, this is a new evaluation, because the one that you had before doesn't count. So it was not in this court, so it doesn't mean anything. So, I mean, it can be used by the other doctors to look at it to see if they think that it has any value in their opinion. But this case is the first time this has come up in this court on this charge. So that's why we're doing it this way. All right. Anything further than come before the court? And for the record, Mr. Smallwood just exited the video room before the end of the hearing.
All right, Mr. Smallwood.
Now we're done with him. All right.
Your Honor, as far as the next hearing date for pretrial.
Yeah, that'll be vacated, the trial date on both, and the case will be told, and then we'll send the hearing out in about 30 days and see what happens there. So, were you involved in the previous examination, Mr. Kirk?
I was.
All right. Well, who was it that did that one?
I know it's not a forensic one, but it was Dr. Hagan.
Yeah, that's the problem. He's not qualified under the law to do these. And, it's a waste of time, because the municipal court really doesn't have jurisdiction to order those, because it doesn't have trial jurisdiction. It just has jurisdiction on trial. So, municipal court cannot determine whether somebody's competent to stand trial. You don't have to be competent to have a preliminary hearing. So. All right. Okay, Mr. Kirk, if you want to come over then, and send Mr. Osborne here, and we'll call Mr. Green's case, who is not present yet in the courtroom that I can see. He may be out in the hallway. Who knows? All right, Tanya Pisser, please.
Is it Madison Ortega?
Yes, please.
She's not here.
Well, she's not in there? All right. How about Luke Robinson then?
No, Mr. Mitchell's on the screen here.
Okay, well, I want to get the jail done first, so. All right.
Yeah, Steve Robinson bonded out, and it's bonded out.
All right, then you have Beth Stewart.
No, she's on the screen. She's
Okay,
there.
then I guess we're done. I guess that's all the ones from jail.
All right.
Let me see here. Yeah, all right, thank you. You can log off then. Thank you. All right. All right, then Tanya Pitzer. Where is she?
Yes, sir.
Okay, there she is. Are you the person that's appearing on the screen that says iPhone?
Yes.
All right. Case number 22 CR 93, State of Ohio versus Tanya G. Pitzer. This is a hearing being conducted, pre-trial hearing being conducted by Zoom. Ms. Pitzer is appearing on the screen marked iPhone. Her attorney is William Armentrout. He is appearing by Zoom in his office, and appearing from the prosecutor's office by Zoom is Assistant Prosecutor King. Defendant is indicted with 4 co-defendants. Looks like she is indicted in counts 1 and 2, and 14 through 17. This is a first pretrial, final pretrial set for May 18. Trial date is June 13. I see that there's been a bill of particulars filed, and it looks like compliance with discovery. You've got that, Mr. Armentrout?
I have it, and I filed my complaints about an hour ago.
All right. Do you anticipate any pretrial motions?
No.
And is a written plea offer?
Yes, Your Honor.
I don't know if it's written, I don't have it written yet, but I did have it earlier on, and I communicated that to my client.
Okay. All right. Are there any other matters that need to be discussed then?
I do have it written in my file, Your Honor, and it's been communicated to my client.
All right.
I know of nothing else, Your Honor.
All right, our next pretrial will be May 18, Ms. Pitzer. and you need to, log into that, you'll get an invitation. Now, I do have a, fax from the probation department that said that, you missed your last report, you called to reschedule, and you failed to show. So, you are to report to the probation department by the end of business tomorrow, in person, and if you fail to do that, the court will order a plea just to issue for your arrest, and you'll be held in custody, and I'll review your bail to determine whether or not you're going to be compliant with the court's order. You understand?
Yes, sir. I just don't have a way to town. That's my
Well,
problem.
you had a way to, you had a perfect way to get to town before, because you were in jail, so, that's not an excuse. You came up with the money to bond yourself out, you can come up with a way to get your rear end to the probation department, and if you don't, I'll set you back out of jail. And if you don't understand that, then,
They have my truck.
I don't care.
That's
not my problem, that's your problem. You came up with the money to bond out, you can figure out how to get to the probation department. And that's what you're to do, by 4 o'clock tomorrow. Where do you live?
Out on Deer Road, on town.
Okay, that's not that far, you can walk. I've had people walk from Greenfield to get to court. So if you need to walk into town to get to the probation department, then, allow yourself plenty of time tomorrow. It's gonna be nice weather. Well, I guess it's gonna rain, bring an umbrella. All right, thank you. You can walk up. All right, let's see, Beth Stewart,
Yes, sir.
case number 22 CR 91, State of Ohio versus Beth Stewart. And you are Beth Stewart, appearing on the screen that says Beth Stewart.
Yes.
All right, this is a pretrial being conducted by Zoom. Appearing on behalf of the defendant is Captain Kantner by Zoom, and appearing by Zoom from the prosecutor's office is Assistant Prosecutor King. The defendant is charged with 4 co-defendants. So she's charged in counts 3 through 5, actually 3 through 9, 3 through 9. This is the first pretrial, final pretrial set on May 18th. Trial date is June 13th. I don't see any discovery activity in the file.
I got it this morning.
Okay. All
I
right.
have not done my compliance yet.
All right, well, I don't even have a request here, so. All right, was there also bill of particulars?
Yes, I requested the discovery bill particulars yesterday. I got the discovery, I haven't got the bill particulars yet.
All right. Yours will be due by the final pretrial. You anticipate any pretrial motions?
I haven't had a chance to look at the discovery yet, so I'll just reserve
Okay.
that.
That'll be due by final pretrial, we determine if there's any that need to be filed. Has there been a written plea offer yet?
I received that this morning, obviously I haven't had a chance to go over that one yet.
Okay. All right. Are there any other matters that need to be discussed then?
Hang on.
All right, keep in touch with your attorney, Ms. Stewart, thank you.
Thank you.
All right,
I'll be over, Your Honor.
wait a minute, I think that, we have Mr. Well, let's see, Mr. Robinson is supposed to be by Zoom. And, who's his attorney?
He doesn't have one.
Oh, that's right, he's in Arizona.
That's right.
Yeah. All righty. Mr. Arjima, have you heard from Mr. Robinson since he bonded out? You're muted there, Mr. Arjima.
I'm sorry, where did you say?
Mr. Robinson, Malik Robinson, he was released on the 8th of April. And he's supposed to be in court today, or it's supposed to be a Zoom hearing. I don't know, but anyway, have you had any communication from him?
Yes, sir. He's been in here. I talked to him yesterday. He's supposed to come in here, I believe, was here at 2.
Oh, wait a minute, maybe that is correct.
I told him to be here around.
No, you're right, it is 2 o'clock, so we're okay. But he's gonna be here in person then?
I was sent to over there.
All right,
He was gonna come here.
okay. All right, then I guess we're done. Mr. Green has not appeared by Zoom, so we'll see if he's gonna show up here today. And Mr. Kirk's on his way, so you come on over, Mr. King, and I think we're done.
Okay.
Thank you. All right, case number 22 CR 72, same with discussion on. President of the United States, Prosecutor King, President of the United States, Burke, or Justin Osborne.
Yes, sir.
All right, this is a pretrial with Osborne, but indicted along with Mr. Shane Elliott, and 4 counts. 2 counts of aggravated trafficking, 2 counts of aggravated possession. Okay. All right, Mr. Osborne, I've been presented with a plea of guilty form, which indicates that you are going to withdraw your not guilty plea, plead guilty to the amended offense in count 1 of aggravated trafficking and methamphetamine, in count 3, aggravated trafficking and fentanyl-related conduct, both 4-3 felonies. This is a 3-page document that prosecutor's office prepared. Page 3, there are signature lines. About halfway down the page, there's a sentence that says, "I enter the plea voluntarily." Immediately below that, there's a signature line, which signature defendant right below that. And I'm looking at what appears to be the signature, Justin Osborne. Is that your signature on that?
Yes, sir.
And when did you sign this document?
A minute ago.
This minute, all right. And did your attorney, Mr. Burke, go over that with you and explain everything to you before signing it?
Yes, sir.
Need keep what's that? And did you understand when you signed this, that this was an agreement to plead guilty between the not going to the trial? The next step in the case would be a sentencing hearing.
Yes, sir.
And had you and he talked about this before today, about possibility of working something out?
Yes, sir.
So when you came here today, is that something you thought might happen?
Yes, sir.
You think you've had enough time to fully consider this matter, make this decision, and sign this agreement?
Yes, sir.
And are you entering into this plea agreement voluntarily?
Yes, sir.
All right, now the agreement states on page 1, going back up, in count 1, you're currently charged with aggravated trafficking, methamphetamine, and 3rd-degree felony. And it's proposed that you plead guilty to the amended charge of aggravated trafficking, methamphetamine, and 4th-degree felony. And that's going to be by reducing the bulk amount.
Yes, Your Honor.
All right. But currently, you're charged with selling in an amount equal to or exceeding bulk, less than 5 times bulk. So that sentence is stricken, and by striking that out, that reduces it to a 4th-degree felony. And then count 3, close plea gives back, which is aggravated trafficking and fentanyl-related compound, the same section, also a 4th-degree felony. Further states that you understand that the maximum penalty for these, each of these offenses could be up to 18 months in prison, minimum could be 6 months in prison, could be a fine of up to $5,000 in each count. It could also be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Right now, if you're convicted of these offenses and you should be sentenced to prison, then you could be sentenced to the sentences could be ordered to be served consecutively. The maximum would be 36 months and $10,000 fine, 2 6 months to 5 year suspension, private suspension. Do you understand that?
Yes, sir.
And these charges were not committed after he was put on community control.
I believe that's correct.
Yeah, I'm pretty sure it is.
Yeah, they were from July of 2021, so I'm not sure they was on community.
July 30, yeah, I think. When did you go into drug court? November, December?
I think it was September.
Oh, September, okay. All right, now, you're not facing any felony charges anywhere else other than the case you're in drug court on right now?
Correct.
Okay. And, you're not on, other than that case, you're not on community control, probation, parole, or post-release control for a felony committed jurisdiction?
No, sir.
Okay. Now, under the law, if you're convicted of these offenses, and if you should be sentenced to prison, upon completion of the prison term, the adult parole authority has the option, if they choose to exercise it, to place you under what's called post-release control supervision for a period of up to 2 years. They don't have to, but they can. But if they do, then you'll be supervised under the terms they set by a parole officer. And if during that period of time they determine that you have failed to comply, they can return you to prison, even though you serve the entire prison term set by the court, for an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term for all violations. However, if your violation is a new felony, then in addition to whatever sentence the judge in the new case would impose upon you, that judge can also sentence you for committing that violation while under post-release control, in this case, to an additional period of 1 year or whatever time left on the period of post-release control, whichever is greater. And if that occurs, that must be served separately to the sentence in the new case. You understand that?
Yes, sir.
Right now, under the law, the court's not required to sentence you to prison for this offense. I can impose what's called community control or probation. And what that means is that instead of being sentenced to prison, you would be put under the supervision of a probation officer for a term of up to 5 years as the term set by the court. And if during that period of time that you were under supervision, the probation department felt that you were not compliant, they would file a notification of that with the court. There would be a hearing. You'd be entitled to have an attorney. And if the outcome of that hearing was that you had failed to comply, then at that time the court would go for community control and then sentence you to prison for 36 months, fine, $10,000. You understand that?
Yes, sir.
I just looked it up on the website. The entry putting him into drug court and community control was on September 22nd. And these cases, he's on there now with 19 cases. Okay. Now, the amended charge in count 1 then alleges that on or about July 30, 2021 in this county, Seth Shane Elliott, you did know the seller officer of methamphetamine and scheduled to control substance. Violation of section 2925.0381. So that's with the amendment, striking out the last allegation, which is the fourth degree felony. Then count 3, alleged that on or about the same date, in this county, apparently you normally sold or offered to sell a fentanyl related compound scheduled to control substance. Also in violation of section 2925.0381 and also a fourth degree felony. Now, Mr. Onberg, do you understand what it is you've been charged with in those 2 counts in the indictment? What the state said you did, what you're now alleged to do?
Yes, sir.
We discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defense you might try to raise the trial, possible outcome of the trial for your attorney.
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made against you to take this plea agreement?
No, sir.
Now, it says on the page, you have 2 and 5 or 4 sentences or 3.5 sentences that are credited bold, underlined, say as follows. Defendant shall under plea of guilty to amending count 1 and count 3, state defense strong recommending control of mission drug court. Defendant agrees to pay back $120 in bond money as consideration for the plea agreement. Defendant shall testify fully with the task force. That's your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that case you plead guilty?
No, sir.
Under the law, matter sentences up to the court. I don't have to follow the recommendation of the party. So even though there's an agreement that you should get continuing drug court and community control in these cases, I don't have to follow that recommendation. I could decide that that's not the correct sentence, sentence you to prison for between 9 and 36 months, and 6 and 36 months, and fine you $10,000 and suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
Now, do you hold any professional license or certification in, from any state government that regulates any occupational profession?
No, sir.
Right now, you have certain rights you need to understand before I can accept your plea. First, you have the right to counsel. Mr. Kirk, would want to represent you. That wasn't simply for the purpose of working a case out, but to provide any defense that could be available to them in the law which you'd like him to provide. So if you decide you don't want to do this, you will still have counsel represent you, including, defending you at a trial, if that's what you want. You understand that?
Yes, sir.
And under the Constitution, you have a right to a jury trial in this matter, in which 12 people will be selected from a group of citizens that reside in this county that are summoned for jury duty under your trial date. After they are selected, the evidence will be presented, and then they will be instructed on the law. That jury will then have to decide whether or not the state proves your guilt by either charge, by proof beyond reasonable doubt, and that verdict would have to be unanimous, meaning all 12 would have to agree on the verdict as to each count. Do you understand that?
Yes, sir.
Now, if you didn't want to have a jury trial, Mr. Osborne, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial. What that means is that instead of the jury being the one who hears the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt by proving unreasonable doubt. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witnesses against you and cross-examine for your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court and testify on your behalf, the same as the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a subpoena, that's a court order, and that would force those people to come into court and be available to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses, of course, come into court and testify against you. You understand that?
Yes, sir.
Right, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can make you testify. The prosecutor can, the judge can. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, except in one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio of every essential element of each offense. So what that means is that the burden of proof is on you to try to prove that you're not guilty of these charges simply because you've been accused. The burden is upon the state to prove that you are. So you don't have to know any evidence at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, you originally entered the plea of not guilty. Not guilty plea denied your allegations in the indictment, denied you committed the crime, and then exercised or invoked all of the rights that I've just described for you. Now, if you change your plea to the first count that's amended into count 3, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, and count 1 is amended, I should say, count 3 admits their crime, admits that you're the one who committed that crime. And that plea waives gives up all of the rights that I just described for you, except your right to counsel. You always have right to counsel no matter what you plead. With that exception, your plea of guilty waives gives up the right to have a jury report trial. Waives gives up the right to confront witnesses against you and cross-examine for your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to come into court to testify for you like the state. Waives gives up your privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. It waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you being sentenced immediately by the court. The court feels that's what should happen. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you to the maximum penalty or under other certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing after being filed. Do you understand all that?
Yes, sir.
And, are you a U.S. citizen, Mr. Osborne?
Yes, sir.
And do you have any questions about the, count one as amended or count three of the indictment? Any questions about the charges or possible penalties?
No, sir.
You understand?
Yes, sir.
Do you have any question about the plea agreement?
No, sir.
You understand?
Yes, sir.
Any questions about the constitutional rights under the claim?
No, sir.
You understand those?
Yes, sir.
And any questions about the plea of guilty, what it means, what will happen if you enter that plea today?
No, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak with Mr. Burke about before you're going further?
No, sir.
Do you have any questions at all about anything I'm explaining here this afternoon?
No, sir.
Then is it your decision to, in accordance with this plea agreement we just went over, withdraw your not guilty plea to count one as amended and count three, and then plead to guilty there too?
Yes, sir.
All right, and as to the charge of count one as amended, which would read that on or about July 30, 2021, Highland County, Ohio, Seth Shane Elliott and you did willingly sell or offer to sell methamphetamine or schedule 2 controlled substance in an amount equal to exceeding bulk amount less than 5 times bulk amount, violation section 2925.03A1, the charge of trafficking in aggravated trafficking in methamphetamine, a fourth degree felony, carrying a possible prison term between 6 and 18 months, a fine of up to $5,000, and a license suspension of 6 months, 5 years, how do you plead?
Guilty.
Then as to count three, which alleges that on or about July 30, 2021, Highland County, Ohio, you can knowingly sell or offer to sell fentanyl-related compound, schedule 2 controlled substance, in violation of section 2925.03A1, Ohio Vice Code, also fourth degree felony, carrying the same penalty as count one as amended. How do you plead?
Guilty.
All right, thank you. Be seated. Court finds on this date open court, defendant is advised on his constitutional rights and no intelligent voluntary order of defendant for the court of 11. Please accept the order of file. Defendant is found guilty of the offense. In count one and count three, in count one is amended and count three, counts 2 and 4 are dismissed. Now, I see in the plea agreement there was a request for a PSI, but I was just looking, I had one in September, and Mr. Osborne has been appearing regularly in drug court every 2 weeks. Is there any need that either party thinks we need to have an updated PSI? Still willing to waive that and proceed in a sense?
We are, Your Honor.
Or King?
Yes, sir.
All right. Anything further from the state? $120 of the task force?
That's the correct, or that's it.
All right, Mr. Kirk?
Thank you, Your Honor. I would ask the court to follow the plea agreement. As we noted a little bit ago in the hearing, these incidents stem from July of 2021. Since that time, my client has entered drug court, and I've been present for some of the drug court hearings myself, and then obviously the court is even more aware that he is doing very well now, and I think we've taken the right steps to address the problems that led to these incidents. I did see a report from FRS dated just about a week or 2 ago, negative drug screenings. He's reporting to FRS, he's reporting to drug court. So at this time, we would ask the court to follow the plea agreement and grant community control and continue my client in drug court. Thank you.
All right, Mr. Osborne, is there anything you'd like to say?
I just would greatly appreciate the opportunity.
All right, well, Mr. Osborne may be the first beneficiary of the court's change in the policy, because I just recently, in the last 10 days, it changed the policy to allow trafficking charges to be found in the drug court, because what we're seeing is some of the lower level type of offenses would be primarily for people with addiction, and so I expanded that. So that's one reason I think the state probably did knock down the first man down to 4 year felon. So you should feel very fortunate for that, over the fact that you were lucky enough that I changed the policy and that the state's willing to knock down count one to do that. Note that I know you just reported that PSI brought back tonight, and I mentioned on the drug court session that you reported last Friday that you had you were going to have 9 months clean. What day was it? Correct.
I'll have 9 months clean on the 23rd.
23rd. I know it's coming up this week. So you're doing what I know you're employed now. You have a sponsor and, you know, going to be, so everything seems to be going well, so court is going to, issue drug court release charges as well. And, it's an order of the court that should be put under, community control on the drug court docket, and the same conditions you currently are already on. I don't know what we're all doing, but you're familiar with those, and, yeah, they're set forth again in this entry, but they're going to be, everything which you're currently doing is just going to be added to this. Now, what this does is gives you a really big incentive to, because I think you have 2 charges before, now you've got 4. And if you don't make any drug court, you end up, going to prison, you've got a lot of time hanging over your head. So, you want to keep that in mind. You're doing well, just want to keep doing everything you're doing. Just keep in mind that, you've got an awful lot of stake here for yourself and your family. And, I want to see you succeed. I really do, but, just keep that in mind. Is there anything for the council? You're released then from pretrial supervision in this case. Report down the probation department to see Mr. Carr, Mr. or the state is let them know to plead guilty of these charges and your drug court on the end of the month. All right, thank you. Mr. Green is on his way. Mr. Ortega for the minutes of law.
Okay.
So he should be here shortly. Actually, 15 minutes, Phil.
Looks like that's on his notice as well, that I see on the arraignment entry.
Oh, is it?
Yeah,
Oh,
2
okay.
o'clock.